Well, good morning. We're pleased to welcome the mock trial class from Centennial Middle School. That's in Provo. Good to have you with us. A couple of notes before we start. As you both know, we're asking questions. It's okay to keep responding. It won't cut into any time. Okay, let's begin with counsel's appearances.
Emily Adams for the appellant Joy Fenstermaker.
Ms. Adams, good to have you with us.
Thank you.
Daniel Day for the state.
Morning, Daniel. Good to have you here. Mr. Day, good to have you here as well. Okay, let's begin.
Good morning, Your Honors. Jory shot Randy once in the abdomen after Randy threatened to kill Jory 3 times back to back. Jory was backing out of a room and Randy kept on approaching him. Randy pushed Andrea out of the way and Randy reached for an area where a knife was earlier in the evening. The jury convicted Jory of murder after receiving improper jury instructions on self-defense. When Jory brought a petition for post-conviction relief, both Jory and the state moved for summary judgment. And the district court granted the state's motion for summary judgment, relying mostly on the conclusion that Jory would not have been prejudiced by incorrect jury instructions, that no matter what jury instructions were given, that the evidence was overwhelming. However, that's incorrect. When examining incorrect jury instructions under the Strickland framework, where we are, this court has given some guidance in Grunwald, which is a 2020 case out of this court, and it asks 2 questions. First, whether the error in the jury instructions created the possibility that the jury convicted the defendant based on factual findings that would not have led to conviction had the instructions been correct.
Well, the instructions were just the statutory language, right?
They were, Your Honor, but under these
circumstances... How is that an incorrect statement of the law?
It was incorrect, Your Honor, because, as we argued, they were absurd. They created an absurd result. And so they should have been modified to either have the forcible felony added in or the causal nexus, which was amended. The jury instruction, the statute was amended in 2018, shortly before or shortly after the brief was filed in this case.
Okay, so which branch of the absurdity doctrine are you relying on? Because one is a canon of construction that requires an ambiguity. Is that the one that you're relying on, or is it kind of an as-applied challenge?
Yes, so it depends on our count. So for the forcible felony, which is count 3, we raised both canons of construction. We said both there was an ambiguous statute because of the word a felony, and then we said it needed, and then we relied also on the absurdity doctrine. We said that we should reform an unambiguous statute. And then for count 4, the causal connection argument, we said just the absurdity doctrine, we need to reform an ambiguous language.
Okay, so for the kind of absurd results part, or the absurdity doctrine, you basically have to have standing to raise that, right? Like you talk about a lot of things, like if somebody's stealing cable or if they're polygamist or whatever, they're committing a felony. But that's not something we get to consider, right? It's about what happened in this case. And so isn't the question that we have to ask for that, whether the legislature could rationally say that guns and drugs don't mix, essentially?
So, Your Honor, you're incorrect. So in State v. Saunders, which is 2019 UT 25, paragraph 51, this court said that courts can find absurdity if they determine that the general legislative policy is absurd, or if the application of that policy to a party under the circumstances presented here yielded an absurd result. So in our brief, we argued that the general policy is absurd. But we also have the facts here to show that under these circumstances, it's an absurd result. That's because, and these briefs are quite old, so I'm going to give you a few citations. The guns and the drugs, the marijuana consumption occurred 3 hours before the shooting in this case. So if we look very quickly at pages 970 and 1059 of the record, we know from those sites that there was a slap boxing match that occurred at 9:30 and the shooting occurred at 12:30. Andrea testified that Jory sat on the bar stool closest to the wall before the slap boxing match. That's on pages 983 to 984. She also testified that they smoked, and then after the slap boxing match, they switched seats. There was a photograph presented at trial of Jory sitting on the bar stool next to the wall with the marijuana in his hands. So it shows, that's Exhibit 36. So because he's sitting close to the wall, that means that he was smoking that cigar or had possession of that marijuana before 9:30, before the slap boxing, I can't say that word, slap boxing match occurred. That means that there's 3 hours between the time when he possessed or smoked the marijuana and when the shooting occurred. And there was absolutely no evidence in this case that the parties were high at the time that the shooting occurred, that they were fighting over the marijuana, or that the marijuana played any role whatsoever in the fight between Jory and Randy. So yes, Justice.
Well, tetrahydrocannabinol affects your perceptions and it affects your mood, right? And that would have been still active in his system at the time.
So there was very little THC found in his system, and there just wasn't very much evidence, Your Honor, from which we can say how affected they were or not at the time that the shooting occurred. And there was one blunt for 3 people.
But
so they all smoked it.
but the felony at issue, I believe, is the restricted person, the possession of a firearm by a restricted person, right?
Yes, Your Honor.
And that has a very, very close nexus to the murder.
No, it doesn't, Your Honor.
Why is that?
The reason that he's a restricted person is because of the marijuana. So the fact that he had the gun on his person and he possessed marijuana 3 hours earlier has absolutely nothing to do with why Randy was shot 3 hours later.
But the actus reus of the felony is the possession of the firearm. And the possession of the firearm is intimately connected to the murder. Would you agree with that?
And you can possess something by consumption. He's still possessing the marijuana when it's in his system.
Yes, Your Honor. Going back to Justice Hagan's question, I mean, the problem here is that we could have somebody sitting in their home with their legal firearm smoking marijuana. Somebody breaks into their house and they shoot them. Does that mean that they are prevented from defending themselves in their own home because 3 hours earlier they were sitting on their couch smoking marijuana? I mean, it doesn't make any sense. The thing is, yes, was the firearm connected to the ultimate shooting? Absolutely. But the reason that he was restricted, the marijuana consumption, had absolutely nothing to do with the shooting that occurred 3 hours later. There simply was no evidence that they were impaired in any way. There was no evidence that there was a fight over the marijuana. There was no evidence that the marijuana played any role.
So is the difference here that he was a restricted person because of something that was not permanent? Like what if he had been a felon and he was prohibited from possessing a firearm at any time? Then would that be connected?
Your Honor, that is a really excellent question. And I think that gets us to, if we look at how the statute was amended in 2018, it says, unless the use of force is a reasonable response to factors unrelated to the commission, attempted commission, or fleeing after the commission of that felony. The question is, what does that phrase mean? This court, and I looked last night, there's been no case law on this phrase. So the statute was amended in 2018, and unless the state can correct me, I don't think there's been any case that has actually interpreted what this actually means and how closely connected you need to be. But I think it is problematic.
But that's not the statute we're operating under, correct?
No, no, Your Honor, but we're saying there should have been a causal connexus like the one that was amended in 2018. And we're saying that our counsel, appellate counsel, because this statute was being passed in February of 2018. It was passed by the House and by the Senate in February of 2018, and it was signed by the governor on March 20th of 2018. And the opening brief was filed on March 5th. So a reasonable attorney would have known what was going on and would have said, I need to be making an argument about causal connection here because, look, even the legislature knows that there's something wrong and is making this change. But back to your question, Your Honor, about what about simply possessing a gun? I don't know if that would be a close enough connection, but here, when we have the only reason he's restricted is because he's smoking marijuana, and there's absolutely no evidence in the record that marijuana played any role 3 hours later, I think that we definitely don't have a causal connection. And I think it's pretty problematic when we pull back a little bit and think about the huge number of lawful gun owners we have in our state who might also do marijuana on the side. Like if they have a lawful gun in their house, but they are smoking marijuana and somebody breaks into their home, the way that the statute is read here and the state is saying it should apply would prevent them from acting in self-defense at all. And that can't be.
But it doesn't
the way of the
exist
statute.
anymore, right?
Sorry, one more time.
But that statute doesn't exist anymore.
No, which is why we're in a bit of a weird posture, Your Honor, because we're saying that this statute was wrong. The legislature ultimately amended it because it was wrong. And had it
Can't the legislature reasonably make different choices? I mean, they reasonably could have said guns and drugs don't mix before, and then reasonably say something else a few years later and say, actually, we see things differently now. Like, different reasonable views of the same scenario are different than something being absurd, right?
There might be different reasonable views, but it is completely absurd, Your Honor, as we've argued at length, because when the drugs happen hours and hours before the gun, and if we had something that said that they were entirely impaired and that certainly that the drugs did affect the way that they were handling the gun, I think we'd be in a different scenario, but we simply don't have any of that evidence here on the record.
Can I return you to the first question Justice Nielsen asked about what version of the absurdity doctrine and can you answer that a little more slowly?
Yes, absolutely.
Because I want to get that answer, but,
yes.
Okay, so on the argument about that it should be construed as a forcible felony, what's the strain of the absurdity doctrine that you're using?
Both.
Okay,
So we're
can
using
you
both.
walk through that?
Yes. So we're using the absurd consequences doctrine because we're saying that under the 2017 version of the statute, subsection 2A2, it talks about attempting to commit, committing, or fleeing after the commission or attempted commission of a felony. So that's the phrase. And we're saying the phrase a felony is ambiguous. It could mean any felonies or all felonies. And we're arguing that this should refer back to forcible felony, which is cited in subsection 1B and also down in subsection 4.
Okay, but when you're saying absurd consequences, so you're saying it's ambiguous, and so we should reform the ambiguity by assuming they wouldn't want an absurd consequence.
Yes. Your
Okay,
Honor.
and
Yes.
then the other argument you're making on that one is if it's not ambiguous.
Okay, yep, so if it's not ambiguous, then we need to reform the unambiguous language from a felony to a forcible felony. That's because it's absurd that the statute would prevent all individuals who are engaging in non-forcible, non-violent felonies from protecting themselves against another's use of unlawful force.
And you're saying you don't need to show that it's absurd here. You're arguing that it is absurd here, but you also don't need to if you can show that as a policy it's generally absurd.
So Sanders does seem to say that you can go both directions, and we have gone both directions in this case. We have did that huge list of like not paying child support as felony, and it seems ridiculous that you shouldn't be able to do that.
Does it matter though if some applications are not absurd? So when you say this is a generally absurd policy, and we can give a lot of examples, but there are probably also a lot of examples where it is not absurd. Does that matter when it seems like you're almost making an argument that it's facially absurd, but there are a lot of situations where it wouldn't be. Does that matter?
So it does matter, and I think that's where we get to the Sanders language, which says that the application of the policy to a party under the circumstances presented here yields an absurd result.
I'm going to push that back on that, because Sanders says in paragraph 54, so that was trying to Mr. Sanders was pressing for an innocent possession defense that came from the drug cases. Apparently it actually came from gun possession cases in the D.C. Circuit or the D.C. Court of Appeals. But at any rate, they were pushing for this innocent possession defense. And we said it is not difficult to conceive of factual scenarios where the lack of an innocent possession defense might lead to an absurd result. For example, if a felon dispossessed a toddler of a loaded gun and immediately placed the gun out of harm's way, we might conclude that a conviction for that behavior would be absurd. But that is not the case before us. So the second strain of the absurdity doctrine is, as I read it, and as applied doctrine, it's like vagueness in the sense that you can't complain of the vagueness of the law as applied to others if it's not vague as to your conduct.
Well, in our conduct here, it is absurd, as we argue it.
No, sure, and I know that's part of your argument, but I think we can think of a whole bunch of ways that it is absurd. I think in Sanders we said the opposite. I said, no, we're not going to consider under other circumstances. We're just looking at this circumstance, whether it's absurd to apply this statute to this person.
And then, Your Honor, Justice Peterson, for count 4, we are arguing that the absurdity doctrine applies, that we need to reform the unambiguous language because there is no causal link. There was no causal link in the 2017 statute.
Oh, go ahead, Chief, you go.
Well, as to the, no, I think that I'm going to start down a different road. So.
Oh, you are? Okay, I do just have one question on number 4. So, in some places in the briefing, you mentioned that appellate counsel and trial counsel should have argued that it was an unconstitutional violation of the right to self-defense. But I don't understand you to be making an as-applied constitutional argument. And so I'm just wondering if you'll clarify, your main argument I can see is the absurdity argument, but there are references to unconstitutionality, and so I wanted to make sure I understood how that fits into your absurdity argument.
Thank you, Your Honor. So I think it's just to bolster the absurdity argument, that given this legal underpinning, the fact that the Utah Constitution strongly supports self-defense, and that's something that's a fundamental right in our state and in our country, that it would be absurd that the statute would take all of that away for an unrelated, nonviolent felony. So it's just to bolster the absurdity analysis. It's not a standalone constitutional analysis.
Because the constitutional claims were raised at trial, so they'd be procedurally barred in post-conviction.
Yes, Your Honor.
Okay.
Yeah.
Okay.
Yeah.
Can I ask one more absurdity question? You've talked about applying the branch of absurdity that applies to, unambiguous terms, right? As reform, we need to reform the statute are the words you are using. And I'm just trying to figure out if that makes sense and exactly how we do that. So if we look at a statute and say, oh, well, that's unambiguous, the language is clear, but it's absurd, it seems to me like the right result then is to not apply the statute to someone. When we talk about reforming it, I start to wonder, so is it reformed now for all purposes? Do people go and look at the statute and then say, oh, I've got to go find this case because the court has now rewritten the statute? Or is it just that the statute doesn't apply? And I think I think that's probably the right result, but I recognize here that gets a little strange, because how do you not apply the statute here where it's providing him a defense? So I'm just trying to see what your thoughts are about that, because I don't really understand what we mean when we say we reform it. It makes sense to me when we say, well, we don't apply it, but do we just come up with words? Is the district court supposed to have created some new statutory language? Curious what you think about that.
So I use the word reform because that's the language that the court has used.
I understand, and understandable, but I'm just not sure. And when we even say that, I then say, well, where's the Reformation, right?
Right. I mean, I would assume that the Reformation, because these are direct challenges to how it was applied in this case, I would assume that the statute would be reformed for this particular case, so there would be some kind of instruction on how to define or modify the statutory language for this particular case. But off the top of my head, Your Honors, I didn't do a deep dive into cases where this court has reformed ambiguous statutes.
Sure.
I'm happy to do a
I don't-
letter on that one for you, but it has been reformed. It was reformed in 2018
Well,
by the legislature.
Well, the statute was, right? But I
Yeah.
think about this case, and it's also why I think it's hard to then look at scenarios that aren't this case, right? Because if we're saying, well, we're going to reform it for this case, that's one thing. If you're suggesting we'd reform it for all purposes, then perhaps other hypotheticals make sense as part of the analysis. But I can't imagine this court stepping in and saying, we're now taking the statute and this is now how it should read with these new additional words. That feels very strange to me.
It does feel like you're crossing boundaries.
Yeah, isn't the answer that the remedy for the absurd consequences, Kevin, when there's an ambiguity, is to read the ambiguity in the defendant's favor? It's kind of a rule of lenity thing.
Kind of a rule.
It's kind of like
Yeah.
that. And the remedy for the absurdity doctrine is it's just not applied to you. It doesn't, you don't reform or do anything with the statute. You just say this statute can't be used under this circumstance. Is that the
But
answer?
as Justice Pullman was saying, if we did that, then he wouldn't have the self-defense statute available.
Right, it makes it complicated here.
I know, it's a very weird situation where the remedy that would have been best for him is what the legislature did in 2018. Like, I think between the forcible felony and the causal connection, I think the causal connection is probably the stronger of the two legal arguments. And what the legislature did in 2018 was exactly what Mr. Fenstermaker needed. And had he been tried under that statute, we wouldn't be here. So as to what this court needs to do to reform unambiguous statutory language, I honestly, it's a complicated thing when the statute has been reformed.
Okay.
So counsel, as to the nexus argument or causal connection argument, I mean, do you acknowledge that under the plain language of the statute, no nexus is required?
Under the 2017 statute,
The
yes,
one
no
that
nexus is
applies,
required.
yeah.
Yeah.
And so it's plain in that sense, in that it doesn't include
Yeah.
any nexus requirement. So you're relying then upon the absurdity doctrine. And so, and correct me if I'm wrong on this, but would my question as a judge be, could a rational legislator have said, you know, you smoke or possess marijuana and have a gun, you do that, all bets or self-defense is off the table? Would that be wholly irrational for a legislature to place that kind of emphasis on the illegal gun ownership?
Yes, Your Honor. It would be completely irrational, especially when the smoking of the marijuana or even possession of the marijuana, you're a restricted person if you just even have it on your person, is not in any way connected to any acts that require self-defense. It is completely irrational. And I think the legislature recognized that when it changed the law in 2018.
Well, I don't know if it goes that far.
Your Honor, it might not go that far, but certainly the legislature recognized that there was a significant problem with the statute. And this court recognized there was a significant problem with the statute in State v. Silva. And Justice Simonis, when he was sitting on the court, mentioned that it was pretty repugnant that somebody, in that case, we were counsel in that case. In that case, it was an illegal immigrant who had a gun, and so he was a restricted person. And he was very concerned with the idea that an illegal immigrant could be in their home with a gun that was unlawful, and somebody could break in to do something that they shouldn't do to their wife and children, and the illegal immigrant couldn't do anything. So I think that there's some very significant problems if we don't have a causal connection, and the legislature recognized that and resolved it.
Do I look to whether any legislature could rationally anticipate that result or want that result?
To not be able to exercise self-defense in
Could it
any
be
circumstance.
any legislator? I mean, some legislature especially sensitive, let's say, to the guns and the dangers they propose, and drawing a bright line. You illegally possess a gun, you've forfeited your right to self-defense.
No, Your Honor, because if you're walking around with marijuana in your pocket and a gun that you have lawfully gotten at the age of 21, like Mr. Fenstermaker, it was a lawful gun. It was proper. He took all the classes, everything. It doesn't make sense if you're walking around with marijuana in your pocket that suddenly if somebody out of the blue comes and tries to stab you that you can't defend yourself. It can't be. It is absolutely not rational. Or if you have a couple leaves in your pocket because you smoked something yesterday and you forgot about it, and it's just hanging out in your pocket, and you're walking around with your gun, and somebody jumps out of the, out of the parking garage and points a gun at you, and you can't do anything. It's absolutely not rational that you should be completely prohibited from defending yourself in circumstances where your felony is completely unrelated to the unlawful use of force against yourself.
You wouldn't be prohibited, you just wouldn't be able to use a gun.
No,
Because you're prohibited from having a gun.
Well, I mean, I don't think you can use any force, Your Honor. So under
Well,
the
if in that situation, so if there's a rule that if you are using drugs, you can't have your gun, and you get attacked, you can defend yourself. You just didn't have your gun on you because you were following that law. Like, if I'm going to start using drugs, I've got to have the gun locked up. I can't be in possession of it. So there's no problem with you defending yourself, just if you're carrying around a gun, there's a problem.
Well, in this is problematic, Your Honor, because if you look at the plain language of 76-2-402, our self-defense statute, it says a person is not justified in using force under the circumstances specified in Section 1.
But then you're not committing a felony, because the thing stopping him from being able to use force is that he's committing a felony at the time. But then you're not committing a felony because you don't.
Well, if the gun is put away.
That's what
Yeah.
she's saying.
Yeah.
So you can use force because you're not committing a felony then.
But if the gun is with you and you have had done drugs at some point and somebody comes at you, the way this reads, you can't even fight back. You can't use force at all.
Yes, that would be
That's
an extra
problematic.
layer of absurdity if you didn't use the gun
Yeah.
and you were just fighting with fists and, yeah. I have one question about, kind of following up on Justice Pullman's question about how do we reform in the situation where the statute's not ambiguous, but there's an absurd application. And I'm wondering if in that circumstance, it's that you don't apply the statute. And I'll explain this a little bit. So an example of an absurd application in my mind is like possession of child pornography. If you're in a trial on that charge, and after the trial is, after both parties rest, you've had closing arguments, the evidence is sent back to the jury. I don't think this actually happens, but it's sent back to the jury, and one of the pieces of evidence is the contraband, the child pornography. And the jurors were charged with possessing child pornography. That would be an absurd application. And if they were prosecuted for possessing child pornography because it was sent back to them as evidence as they were acting as a jury, I think that the remedy would be it's an absurd application to prosecute them for possessing something, possessing contraband, when they only possessed it because it was in the room with them as a jury. So we wouldn't apply it in that situation because it's absurd. And here, I don't know that it's the entire if we were to agree that it's absurd in this situation, I don't know that the entire self-defense statute wouldn't apply, but the part of it that says you can't claim self-defense if you're committing a felony, that provision may be absurd. And so that would not apply. If we decide that can't possibly be what they meant to do, that would be absurd, so we're not going to apply it here. I just wanted to get your thoughts on that.
I actually think the cleanest way forward would be to remand the case for a new trial and say, use the 2018 statute. Just use the language that is in that 2018 statute, because I think there's a good argument that this needs to be in here, is attempting to committing, or fleeing after the commission of an attempted commission, fleeing after the commission or attempted commission of a felony. That's a really important piece of the state's case that the state needs to argue. I think what we're arguing is that there just needs to be this causal nexus there. So I think it makes the most sense for this court to remand and say, just apply the 2018 statute. Just put that causal language in there, and then it allows the state to argue that Jory was committing a felony and therefore is not entitled to self-defense. And it allows Jory to say, hey, there just wasn't enough of a connection here, so I should be able to claim self-defense. I think that gives both parties what they need and would be the fairest way forward.
What does the new statute say about a forcible felony?
The new statute says, I only have the 2018 statute with me, Your Honor, but but I don't believe the forcible felony it's been moved up in the statute, but it hasn't substantially changed. But it says, it just defines it. It says it includes aggravated assault, mayhem, aggravated murder. So it's all of these violent crimes. And then forcible felony is also discussed in where you're justified in using force intended or likely to cause death or serious bodily injury, only if you reasonably believe that force is necessary to prevent death or serious bodily injury to the person or a third person as a result of another person's imminent use of unlawful force or to prevent the commission of a forcible felony.
But it didn't add forcible felony to the provision that you're talking about. It didn't modify that.
It did not modify that because it resolved the problem by.
Why does that not cut against you?
That the
fact that they were changing the nexus issue along the lines that you think made sense, but declined to insert the forcible felony requirement.
Well, I think that we've argued two alternate paths, and we can win on either ground. Either it needed to be remedied because we needed to add forcible felony, or it needed to be remedied because of a causal nexus. I think either one of those gets us where we need to go.
Yeah, this is a slightly different question, but did you have a thought?
No, please finish.
Why was it unreasonable, especially in light of what you just said, for counsel below to focus on the forcible felony argument as opposed to the nexus argument?
So trial counsel was unreasonable because trial counsel put a lot of effort into the forcible felony argument, but also recognized that there was a problem with this causal link. In the objection to the jury instructions, counsel said there ought to be a causal link, but didn't go further into it, didn't propose a jury instruction. And when we get to the jury instruction discussions on page, I think it's like 620 of the record, counsel says, oh, we just need to put in here that the felony needs to be nonviolent, that you're not allowed to exercise self-defense if you're committing a felony that is violent. The problem is the causal connection was a clear issue in the case. And then when we get up to appellate counsel didn't raise this issue at all. Appellate counsel had 11,000 words in the opening brief, so there was space to argue for a causal connection. The forcible felony and causal connection arguments, it's not an either-or situation. They support each other, right? The one makes the other stronger. So this isn't a case where you're choosing between two issues, one that makes the other issue weaker. That's not the circumstance here. So it's not an either-or. Counsel had space, and appellate counsel should have known that the legislature was changing the law. The appellate counsel was writing the brief at the same time that the state and the House had already passed changes to the statute, indicating that there was a problem. So it's a reasonable attorney in those circumstances would have raised the causal connection argument in the opening brief.
Have you undermined your forcible felony argument by admitting that, let's say that there was incontrovertible evidence that he was super high. He had been using a lot of some illicit substance to the point that it was severely impairing his judgment and his thinking processes and things like that. That would not be absurd to say that person shouldn't be able to have a gun, right?
Right, because I think then we have that causal connection.
Okay, but then that's not a forcible felony.
Mm-hmm.
So why would the forcible felony thing fix it?
Well, I mean, the thing is, we have a problem with.
That's under-inclusive, it seems.
Yeah, I mean, the thing is that we either have, we're criminalizing, we're not allowing people to act in self-defense when they're committing nonviolent crimes. And
Well, it's a nonviolent crime to be super high and have a gun, right?
mm-hmm.
But it certainly affects the use of force in that person's mental state.
It might.
And that's might, I mean.
In this case, it did.
Under my hypothetical, it absolutely is. That's what I'm saying. Assume that somebody is super high and very severely impaired. That's not an absurd result, and that's not something the forcible felony thing would fix.
It's not something the forcible felony thing would fix. So I think that when we get to the, that's why the causal connection is a bit stronger. But the thing is that in this case, Your Honor, there is no evidence, like I said.
No,
that he was
I
incredibly
understand
high.
that's not this case. I'm just saying the forcible felony argument may work under the facts as you see them here, but it wouldn't eliminate this charge under all circumstances.
No, it wouldn't, Your Honor.
Okay, thank you.
I'm having a little bit of a hard time with the prejudice part of the causal connection analysis. My initial reaction is that even if the new statute was in effect and the jury was charged in this way, I'm having a hard time seeing how illegal possession of a firearm isn't related to the actual use of self-defense. Can you make your best argument there?
Right. So, Your Honor, we hear all the time that people, what is the saying that we hear a lot in the Second Amendment? It's not the gun that's the issue, right? Here, it's not the gun that's the issue. Yes, eventually Randy was shot, but he was shot in the abdomen. This was not a shot to the head like in Silva. This was very much a self-defense shot. It was a one shot, it was to the abdomen, and it was while Randy was turning, right? Because Randy was shot in the side.
But I guess here's one of the facts that bothers me, is that the weapon was drawn before what your client alleges is what gave rise to his reasonable fear, right? There were the threats that if something happens in the future, I'll kill you. I get that, but then your client drew the weapon and started backing away, and at that point, he says that the victim stood and turned towards the counter where he thought a knife was. And so I'm just having a hard time understanding why him being in illegal possession of a firearm, drawing that firearm, escalating the fight is not related to the factors that that gave rise to the use of force here.
Right, Your Honor. So he drew the firearm, but he's being charged with shooting the firearm.
Sure.
And after he drew the firearm, after Randy had said, "I will kill you" 3 times, and Andrea made it clear, she was asked on cross-examination multiple times whether this was a future threat or a threat for something that had happened in the past, because money had been stolen. And she admitted on page 1054 that the threats were about future incidents and about the prior stolen money. So here we've got a factual dispute for the jury. Were these threats like, "I'm going to kill you in the future," or "I'm going to kill you because you stole money from Andrea," or your friends stole money from Andrea? And that's not clear in the record which way it was. When Jory pulled his gun, Andrea testified that Randy put his hands up, but she told police that Randy smirked. He smirked at Jory, and that's on page 975 and 1090 of the record, and that he did not put his hands up. So we've got a factual dispute there, both from Andrea's testimony. She testified that she put herself between Jory and Randy, and that Randy had gotten up and walked, and he was like right behind her. So he was advancing on Jory, and she turned around and tried to push him so he would sit down, but he didn't move at all, and that's on page 976 to 977 and 1090. And then Randy pushed her to the side with both hands, and Andrea testified that she was pushed so hard she had to catch herself on the wall, and that Randy seemed angry with her, and that's page 1092 of the record. So we have all of these things leading up to aggressive actions on Randy's part.
Right, but let me ask you this point. Before the point where your client pulled the gun, is there any argument that that was either perfect or imperfect self-defense? If he had shot him right then, let's say that right when your client pulled the gun, instead of just pointing it at the floor and backing away, he had just pulled the gun and shot him. Would you have any argument for self-defense in that situation?
We might have an argument for, not for perfect self-defense, I don't believe so. Maybe for imperfect self-defense. But here we have the pulling the gun, the advancing, the pushing Andrea out of the way to get to Jory, and the fact that he's turning and reaching for the counter, which was, if you look at the exhibits, Exhibit 18, it's very cluttered, and Andrea testified that there were 2 knives on the counter about an hour before.
I get all of
right?
that, but it all happened after he pulled this gun that he was in illegal possession of. And that's what I'm struggling with, is how is him being in illegal possession of a firearm not part of the factors that gave rise to this claim of self-defense?
Because Randy was coming at him. He was threatening him. He was aggressively moving towards him. He was pushing Andrea out of the way. And it wasn't the fact that the gun didn't cause the argument between Randy and Jory. The gun was there, but it wasn't in any way part of the argument. And so it was something that Jory pulled as a way to defend himself, but it wasn't the source of the argument. And I think that's maybe where the causal connection, where you're seeing it, if the gun hadn't been there, Randy wouldn't have died. I don't think that's what the causal connection means. It means that is the self-defense, is the reason that you need to act in self-defense related to you in an important way committing this other felony. And here the gun didn't have any role. It wasn't that they were fighting over the gun. I think that would be a different circumstance. If they were fighting over the gun, maybe we wouldn't have a causal connection. Maybe we would have a sufficient causal connection there. But there wasn't any fight over the gun. The only reason the fight started was because of Randy making all of these improper comments late into the night. They acted fine for the first 7 hours of being together, and then Randy started acting strangely.
It just does seem like it escalated it. I mean, this is not a situation where you have someone minding their own business, sitting on their couch watching TV, and there's a home invasion, right? I mean, and they shoot someone in response to that. This is a situation where there was no even colorable self-defense claim until the gun was drawn that he was in illegal possession of, and then that escalated the fight.
I think there could have been a colorable self-defense claim, even
Okay.
though if it was imperfect at the time, because we had 3 threats. the "I will kill you," which Andrea clarified that could have been for the past and the future. And when somebody threatens to kill you,
Well,
it's
she
pretty
didn't
important.
really clarify that. Like, as I read her testimony in context, she was saying what made Randy mad was that Fenstermaker's friends had stolen money from Andrea's purse. And that's what got him think. And he's like, "Did you have anything to do with that?" "No, I didn't have anything to do with that." And then then he started saying, "Well, you, in the future, you better take care of my girl here. You better have her back. You better not be stealing money from her purse." And that's the context in which the threats were made. So what prompted the conversation and the threats about the future was the fact that his friends had stolen money from the purse.
So, Your Honor, that is partially true, but then we get to the cross-examination on page 1054, where she seems to admit that the threats were potentially for having his friends steal the money and him not protecting her back then. So I think it goes both ways. I'll also say, Your Honor, Justice Hagan, that there was a slap boxing match a few hours before where Randy flipped Jory. Randy's 50 pounds heavier than he is, right? And it was pretty aggressive. It kind of threw Jory off. And that's one reason why he switched the placement of the stools, because he didn't want to be stuck next to the wall with this big kind of aggressive guy next to him. Randy also was pretty drunk. His blood alcohol, I believe, was at 0.24 when he, or 0.19 when he died. But earlier in the evening, there's some testimony that it was actually going down. It was like 0.24 higher. It was higher. It was at 0.24. And so he was getting more sober, but also he was, I think, a fairly dangerous individual, given the fact of his intoxication. Unless this court has any other questions. Thank you.
Thank you, Ms. Adams. Mr. Day.
May it please the court, Daniel Day for the state. I think it's helpful to frame where we are in this case from the get-go here. This is an appeal from a post-conviction case where a district court analyzed the ineffectiveness claims against the appellate counsel, made factual findings, and did the prejudice analysis, which Fenstermaker is asking this court to review. And under those standards of review, counsel's arguing this case like you're a jury, but we're reviewing the district court's granting of the state's summary judgment because as the facts as the district court found don't support any of Fenstermaker's prejudice claims. Appellate counsel was not ineffective for not briefing prejudice on the forcible felony jury instruction argument because the outcome of the appeal would not have been different even if he had gotten the instruction that he requested because the evidence that Fenstermaker shot Randy and killed him was that was not self-defense was overwhelming.
I think if it were just perfect self-defense, I think that's a strong argument. I think it's a little bit harder to argue that on imperfect self-defense because imperfect self-defense is self-defense that's just a little off. Maybe it's not imminent. Maybe it's a disproportionate use of force, that sort of thing. With the threats and him coming at Mr. Fenstermaker, isn't there potentially an imperfect self-defense claim there?
No.
Why not?
Well, first, the jury was instructed on imperfect self-defense.
But they were also told they couldn't consider self-defense if they thought he was possessing a gun while he was, what they convicted him of, right? Being a felon in possession.
Right. And Fenstermaker's not challenging that conviction.
No, I understand that, but he's
yeah.
saying that if the jury was allowed to consider self-defense, then isn't there a reasonable likelihood, at least on prejudice as to imperfect self-defense?
No, not under these facts, and not under the facts that the district court found, which under Torziana, this court would have to find to be clear error, which Fenstermaker does not really even challenge. This, whether Randy was charging towards Fenstermaker only comes from Mr. Fenstermaker's testimony. A jury could obviously reasonably not believe Fenstermaker when all the other evidence suggests that Randy was not charging towards him. In fact, when he was shot, he was turned sideways. And even under imperfect self-defense, no reasonable person would shoot somebody who, again, Fenstermaker also acknowledged that he didn't know whether he had a knife. He didn't see him with a knife. There was no evidence of any knife. He didn't really bring up a knife until after the fact. And so...
Well, he brought it up right away, right? in the text, in the Snapchat to
Yeah, that-
Andrea while he was on the run. He
That's the
said-
first time it's raised.
Well, that's kind of moments after the shooting, right? That's
The
when
police were there
Yeah,
at-
the police are there. And it says, there were three things, right? Like, I wasn't there, he had a knife, I left, something like that,
Sure.
right?
Yeah, and,
So he brought it up pretty early.
right. But even
He
in that,
lied- He lied in that text too. I
one of those things is,
I
several of
wasn't
those
there-
things.
I wasn't there was an obvious lie, yeah.
Sure. He had a knife, I left. He certainly left and didn't come back for several hours. One of the reasons why there's very little THC in his blood and
14 hours later.
right, or alcohol. So that was a question for the jury. The jury had all of this evidence.
But they couldn't consider imperfect self-defense under instruction 66, right? If they believed what they believed, which was he was a felon in possession.
Right, and that question goes to, did he possess or control or use marijuana and have access to the gun, which is, that's what they convicted him of. That's not being challenged, and that's undisputed. So he was a restricted person, which is defined as a violent felony. So this issue of, it's not a forcible felony, but again, the statute has since been amended, and it still doesn't say forcible felony there. And with regards to causal connection, I think we disagree that, or with Mr. Fenstermaker, that there's no causal connection here. But
Can you explain that a little bit more? What causal connection do you think there is?
well, under the old.
Is it the actual, let me be more specific. Is it the possession of the firearm, or is it the use of the marijuana, or both, that you think is causally connected?
It's both, because you're not a restricted person unless you are a felon, which is using or possessing marijuana and have a gun, and that gun was used to kill Randy. There's a direct connection there. Perhaps this language that came after the fact was related to these these situations about stealing cable or not paying child support or things of that nature, which certainly wouldn't be connected. But in this case, that causal connection is there.
Okay, tell me this. Let's say that he was a restricted person because he was an addict, or because he was a felon. Something that couldn't have any real connection to his use of the gun in alleged self-defense. If the reason he was restricted was unrelated, would that render his felony, illegal possession, unrelated? Or would illegal possession still be related because he used the gun that he shouldn't have had in self-defense?
Yeah, I think it would depend on the underlying felony. There's cases where of just drug deals, which obviously don't have any inhibition on your ability to use a gun. It's just involving guns or possessing methamphetamine or any other type of drug is a felony and is charged under self-defense is oftentimes in those cases not even given to the jury.
Okay, so let me ask it a different way. If someone killed someone in self-defense with a gun that they were prohibited from having because they were a restricted person, would that always be related? Would that always have a causal connection to the claim of self-defense, or the factors? How is it worded now? Would that always be related to? Let's see. They say it in the negative, so it's a little tricky. Unless the use of force is a reasonable response to factors unrelated to the commission of the felony. So would killing someone in self-defense with a gun always be related to the commission of possessing that gun illegally? I'm just trying to think if there's a scenario in which someone could be a restricted person and not allowed to have a firearm, use that firearm in self-defense, and have that not have a causal connection. Does that make sense?
Yeah, and the way I read the statute and the restricted person, framework, I think that it would always be connected. And it's certainly connected here. And on this causal connection issue, that's procedurally barred. And the district court found that because this issue was raised by the trial counsel pre-trial. The court, in its post-conviction ruling, addressed that and said, I was aware of it. If I thought that the facts or the circumstances made it so that would have mattered to me, I would have ruled on it. And under the procedural bar, there is, it says in the statute whether it was raised or addressed. And in Hand, this court explained that an individual claim need not itself be adjudicated or addressed on its merits to be barred under the PCRA. The statute clearly sweeps more broadly than that. So
do you think it's more broad than the preservation rules? So for example, if that's all that had been said and someone was up here arguing the issue, right, as a preserved challenge, would the state be here saying, him just mentioning it, the court maybe hearing it, but no one asked him to rule on it, that it would be preserved?
Perhaps not. But here we have a district court making a finding that he was aware of that claim, and it wasn't part of his ruling. But if he thought it had any merit, he would have ruled on it, or he would have said something about it. He would have granted it.
But I guess the question, so aside from that finding, do you think that it's that the standard's lower, right? That raising an issue for purposes of this procedural bar, there's less that needs to be done to raise the issue than what needs to be done to preserve an issue? Or are those similar things? Because I think if I was looking at this from a preservation context, I think I would rule it's not preserved. There was a side mention, but nothing really said about it, nothing really asked for. And so I'm just trying to decide whether or not this is a lower bar than that, or if those mirror each other.
I think it's lower, and I think the point is because on post-conviction you've had trial, you've had an appeal, you've had this in front of a district court, or you're raising it to the district court hoping to get an evidentiary hearing. The point is finality and making sure, these are ineffective assistance of appellate counsel claims on claims that a trial counsel was ineffective for not raising. Well, trial counsel cannot be ineffective for not raising a claim that he did raise. The claim would have to be on post-conviction that appellate counsel was ineffective for not arguing that trial counsel was ineffective in the way that he raised it. In effect, he was ineffective in the way for not getting it in front of the court in a way where he absolutely would have said something about it, even though the court here said that he was aware of it.
Can I ask you one question back on imperfect self-defense and the prejudice and the failure to make the prejudice argument? What factual findings of the district court do you think are the ones that would preclude an imperfect self-defense finding by the jury?
Yes, and this is all from the district court's findings. That Randy was seated and unarmed when the gun was drawn. That Fenstermaker knew Randy was so intoxicated he could barely stand. Randy's threats were not immediate and they were contingent on future events. Fenstermaker admitted he never saw a knife. Fenstermaker shot Randy from the side, again, indicative of him not charging towards him, but turned. After the shooting, he told no one that Randy, he didn't tell the police he had a knife. There's this, again, there was this Snapchat text a little bit afterwards, which has, conflicting things about what was true and what was not true. All of these facts show that it was objectively unreasonable for somebody to shoot somebody who didn't also have a gun, was turned away, and you had a wide open door behind you.
One of the reasons that I think it's difficult, and my takeaway from Torres-Oriano was that we don't defer, right, to the prejudice findings. One of the reasons that I think that it's difficult to say that these are factual findings that we defer to is because it does seem like the facts are presented in the light most favorable to the jury's verdict. And I'm not sure how we can view facts that way when we're doing a counterfactual prejudice analysis. Can you address that?
Yes, and again, this being on post-conviction, I think frames it a little bit because if in some post-conviction circumstances we have new evidence being brought that wasn't introduced at trial that the defendant claims would have changed the result of trial, changed the evidentiary picture, you would view those on summary judgment in the light most favorable to the defendant under the summary judgment standards. But when you're in post-conviction and you're just arguing prejudice like the trial was given, we have a jury verdict. We have a direct appeal affirming that verdict, and the facts need to be viewed in the light most favorable to that verdict. Because because it's a civil case, you don't wipe the slate clean. We have all of this evidence was already presented to a fact finder, and they made credibility determinations and findings on guilt that require a lot to overcome. And in most instances, that will require new evidence that they wouldn't have considered. This is just a legal argument that they're saying would have possibly changed the result. But when you do the counterfactual, you just plug in this the statute that they want with the evidence that the jury already had, and it still doesn't meet the prejudice standard.
And I get that. I'm just wondering if we can, for instance, assume that the jury made credibility findings. I mean, the Grunwald case that was cited earlier, I think that this court was pretty clear in overturning the Court of Appeals prejudice finding that we don't assume that the jury would have made the same credibility findings under the counterfactual analysis. That's I guess what I'm a little bit confused about is how can we assume that if the jury had been instructed differently, it would have viewed the facts in the same way that it apparently did? Isn't that contrary to doing a counterfactual analysis?
I don't think so, not under Strickland. And Fenstermaker raised Grunwald here and in the Court of Appeals. It was not cited in any of the briefs. And if Grunwald is being used to just support their argument, and it wasn't so important to include in their briefs, then this court should just follow Strickland. But if Grunwald is so important that they're relying on it, and this court thinks it's a close call under Grunwald, the state would ask for supplemental briefing, because the state believes that Grunwald does not follow Strickland in the prejudice analysis, and we would like the opportunity to respond to that in the briefs. On, again, whether the statute is ambiguous or not under the absurd consequences or absurdity doctrine, I think it needs to be one or the other. Either it is ambiguous and the court reads it in the way that creates a less absurd result, or it's not ambiguous and the court's going to move away from whatever the statute says. And there's this discussion about whether this court can consider other circumstances where it may be absurd. This court in Utley, said that when a statute is unambiguous, and this is under the absurdity doctrine, the statutory language is almost always irrefutable evidence of the legislature's intent, even if it leads to results the court regards as impractical or ill-advised. And that concept is that we take the legislature's words as they mean them, and whether it creates an absurd result in a particular circumstances, that has to be a very absurd situation. And in my experiences, when that happens, it's sort of a typo cross-referencing the wrong part of the statute. It's not providing defenses to defendants who aren't entitled to them under the statute as it's written.
Can I have you return to the imperfect self-defense issue and prejudice? I'm not sure I fully understand your argument. I do think you do have a pretty strong argument on prejudice on just regular self-defense, but I, like Justice Nielsen, just have some concerns about how we can say that there's no reasonable likelihood that a jury, if they had known they could really consider self-defense here, would not have possibly believed him and his assertions that he thought the self-defense was necessary. Can you help me walk through that prejudice analysis?
Yes, because even if, say they were allowed to consider the self-defense statute, he was disqualified under other parts of that statute because he was the aggressor. He pulled the gun. He shot Randy when he wasn't looking. You can look at other parts of this.
Was the jury instructed on that aggressor
Yes.
part of it? They were?
Yes. They were given the statute as it reads, which had, other things other than this, a felony part or committing a felony part. So, we can't speculate on which part of the statute they decided to, disqualify him on, but that's because, under any circumstance that he wasn't entitled to self-defense under perfect or imperfect.
So was the testimony, when he pulled the gun, what was the testimony that he and the expert that he called about pointing it at the ground? That if you think you may need to use it and the person's within 21 feet of you, that you don't point it at the person, but you point it at the ground so that it's in a ready position. How does that factor in terms of the kind of escalating things by pulling the gun?
Yeah, this 21-foot rule is about the ability for somebody to reach you or attack you within 21 feet. And it's about drawing the gun. So he drew the gun, but it's essentially about drawing and shooting, is my understanding. It's not about just drawing it. Because if somebody's coming at you, obviously you're not just going to draw it, you're probably going to have to shoot them too. But here, Fenstermaker just drew the gun, and this 21-foot rule is sort of irrelevant to that.
Was the testimony or the evidence that he pointed it at Randy or he pointed it at the ground?
The testimony was that this is Fenstermaker's testimony, is that when he drew the gun, he pointed it at the ground, but Andrea said that she went in front of the gun, pointed at Randy, and said, "You'd have to shoot me," and Fenstermaker said, "I'll do it," essentially, until Randy pushed her out of the way and was turned, and then he got shot. And so a lot of the circumstances of what, whether it was imperfect defense or not, anything supporting that almost came exclusively from Mr. Fenstermaker. And the jury was also aware that, he had lied to the police before. That came into evidence. And again, the jury's making these credibility determinations based on the testimony of Andrea, based on the evidence of the scene from the police, and also based on Mr. Fenstermaker's actions after the fact. Again, he could have just walked out of this door. There was only a screen door in the way at the time. And his actions after the fact, running away, disposing of magazines and the gun, not telling his friends anything about what happened when he picked him up, not telling his girlfriend anything about it. His mother had to come and pick him up and take him to the police hours later. So the jury had all of this in front of it, and whether he had gotten these instructions or not, the result of the trial would not have been different.
Can I ask one last question? It's a short one, I think. I found it odd that the district court here gave the jury instruction on self-defense, but yet in the summary judgment decision said there wasn't a legal basis to assert the self-defense. That seems inconsistent to me. Isn't he the same judge that let the defense go to the jury?
Yes, I believe so, because he mentions remembering things and of that nature. Obviously, because he remembered this nexus causal connection argument that was raised that he was aware of. I don't know that it's inconsistent. There's a lot of cases that say if a defendant requests an instruction, it would be error for the court not to include it. I don't believe that the self-defense statute is one of them, but and I think the state even argued that he shouldn't have, and the trial court allowed it, and the trial court has that discretion for belt and suspenders. Okay. But I think that if this instruction was not even given at all, I think the state, the the facts support the conviction in any event, because it wouldn't have applied. Thank you. We ask the court to affirm.
Thank you, Mr. J. Ms. Adams.
Your Honor, it's important when you're thinking about prejudice to understand that this is a split verdict case, that the jury acquitted him of aggravated assault, and it was undisputed that he pointed the gun at Andrea and told her that if she didn't get out of the way that he was going to kill her. And yet the jury believed his testimony and his argument that she stepped in front of the gun, and so he wasn't intentionally trying to harm her. So this is a split verdict case. This wasn't something where where the jury was completely overwhelmed by the state's
Well, do we
evidence against
really know that? I know we've said that before, but split verdicts are like reading tea leaves, right? We don't know why juries do things, and that's by design. I mean, sometimes you know because you go and ask them as a trial attorney, and they tell you, but that you don't get to impeach their verdict with that, and for good reasons. But does a split verdict really tell us very much? Can we tell what it means? I mean, maybe they were exercising some lenity. Maybe they thought he's got enough, for this criminal episode by getting 2 convictions instead of 3. Maybe, can we really even figure out what that means?
Your Honor, you can figure out what it means to the extent that you say that the jury was not completely convinced by the state's case.
Well, I'm saying we don't know that. Do we? Does the split verdict really tell us that? It might have been just they couldn't agree and they decided to lay that one aside. Like, does it really tell us they didn't believe it, or is it just kind of like, who knows what that means?
Right, Your Honor. So it's true that we don't know exactly why they issued the split verdict in this case, but I think it's reasonable to say whenever we get a split verdict case that this is a jury that wasn't entirely convinced. Something else was happening here. And so therefore, I don't think the state's arguments that there's all this overwhelming evidence against Jory should be taken at face value. Just really quickly, the state argued that Jory was the aggressor. But in this case, I think the jury could have reasonably said that Randy was the aggressor, because Randy was the one who said, "I will kill you 3 times," and put his forehead, against Jory. So a reasonable jury could have said, it wasn't Jory that was the aggressor here, it was Randy. Also, going back to causality, I think I finally have a sort of answer for you, Justice Hagan, which is really exciting for me. I think that when we look at causality, the difference is between but-for causation and proximate causation and intervening cause. So if you have an unforeseeable intervening cause between your possession of a firearm, unlawful possession of a firearm, and the actions which cause self-defense, I think that breaks the chain of causation, just like we have in our regular tort cases. So if he was fighting over the gun, I would say we absolutely have a causal link. That gun is related to this action that is causing his need for self-defense. But if you're just carrying around a gun and had smoked marijuana 3 hours earlier, which makes you a restricted person, and then, in this instance, Randy randomly starts saying, "I will kill you," and then you start feeling like he's going to hurt you. Those things, Randy's statements and his aggressive actions are an unforeseeable intervening cause that breaks the chain of causation. Also, just quickly, if I could make one more point, Newton helps us here, the case that this court just released back in December. It talks about the standard and burden of proof and how you view how you view the facts here on summary judgment. Justice Hagan, I take your point that I think it's very problematic that that we're viewing the facts in the light most favorable to the jury verdict when we're on a Strickland counterfactual analysis, and also when we're on the state's motion for summary judgment. Generally, when you're on a summary judgment motion, you're viewing the facts in the light most favorable to the non-moving party. I think, and also we've made lots of arguments that this is not procedurally barred. Just briefly, even if trial counsel did make that argument, Justice Pullman, I agree it certainly would not be preserved. We'd have to argue super hard that was preserved. It wasn't something that that appellate counsel brought up, and this court said in Newton that you can have independent actions for appellate counsel's ineffectiveness.
Can you just tell me one more time
Yes.
on the intervening cause? And so what do you think that the cause, so when it says, unless the use of force is a reasonable response to factors unrelated to the commission of that felony, what kind of did you say but for, did you say proximate? What do you think
if we have
that
an unforeseeable intervening cause,
okay.
those are factors unrelated to the commission of the
Okay.
Let's see, now I've messed up my language.
But how?
Yes.
But instead of talking about intervening cause, what causal connection do you think it requires? Do you think it's a but-for cause? Do you think it's, I mean, what do you think is required by the new statute?
I think that we need to argue proximate causation. I think there
Okay.
needs to be some kind of foreseeability here.
Okay.
Because if you are, for example, if you're fighting over the gun,
Okay,
they've got a direct causation here. But if it's kind of unforeseeable, somebody jumps out, if you're carrying your gun and smoked marijuana 3 hours before, and somebody just jumps out of the bushes at you, for no reason whatsoever, you should be able to defend
Okay.
yourself.
got it, thank you.
Unless this court has any other questions? Thank you, Your Honors.
Thank you. Thank you to both counsel. We appreciate the arguments, both written and oral. And we will take this matter